Thank you very much, Rosa. Firstly, thank you for the invitation. It's a privilege to be able to present to this wonderful audience. So thank you to Parramatta Chamber of Commerce, Rosa, the board, our guests and visitors. Dominic Fester, Employsure. Who is Employsure? We're Australia's largest independent provider of workplace relations advice. We cover all aspects of employment law and workplace safety. Okay, so if we look at those two jurisdictions that we play in, that's very much for a business to establish the legal floor of compliance, which then is completed by the likes of Anthony Mazza, who is an accountant and bookkeeper, and that takes care of all your ATO compliance, tax and super, and so on and so forth. So collectively, if you look at it as a strategic partnership with Employsure and MazCorp, right, employment relations, work health and safety, and finance and tax compliance, you've got a very solid business, okay? So what we're here to do today, and I'll turn this over to Gwen shortly, who is way more of an expert than I am at these things, to then populate it with the information, the intelligence around how we can help support businesses, create frameworks, and drive it forward in the future. Quick backstory, Employsure's been going about 10 years. We started with about 9 staff and 100 customers in the first year, and we've grown to approximately 900 staff and over 28,000 customers within that 10-year time frame. And we've got some great stories along the way. So without further ado, I'll pass it over to Gwen, please, my HR business partner.
Thanks, Tom. Good morning, everyone. Privilege also to be here. For those of you who are not familiar with me, I'm all the way down in Launceston in Tassie, where this time last week it was snowing. It's not snowing today, which I'm quite pleased about. I'm just going to share my screen, so just bear with me for 1 second. Let's make sure we get this up. Come on, there we go. So as Dom said, I'm a HR business partner with Employsure. I've been with the business almost 2.5 years, and love being able to help our clients sort of navigate what is one of the most complex industrial relations systems in the world we kindly have here in Australia. So 3 sort of main areas of topic that I wanted to cover this morning. A little bit about hygiene and safety specific to COVID. We all know about health, WHS, work health and safety, but specific to COVID, what are your obligations and how can you make sure that your workplace is safe for your employees? Then something that is absolutely a hotbed right now is unfair dismissal and redundancies. We have seen something like a 70% increase of unfair dismissal claims going through to Fair Work. Not because employers are doing the wrong thing, but because employees understandably are in a self-preservation mode at the moment. So they're looking for, something to help them get from having lost their job to finding another job. And then a little bit about engaging employees in this very, difficult and interesting time that we find ourselves in across the country. So let's have a look then at hygiene and safety specific to COVID particularly. And what we want to have a look at is, many of you, some of you may have had instances in your business where you actually had to close your office or close your businesses and have your employees either working from home or stood down. And now as you're bringing them back into the workplace and getting back to some sort of normality in business, what are your obligations around that, particularly from a work health safety perspective? And what happens if you've actually got an employee, touch wood, it never happens, but what if you have an employee actually is diagnosed with COVID? What are your obligations there? So the first step is something you would likely be familiar with, and that is doing a risk assessment. So the risk here that you're looking at is what is the risk that COVID could be transmitted in my workplace? And then how serious would the consequences be if that was the case? So, and that would depend on your industry, on your type of business, and the type of employees that you have. So, if we were to use a really obvious example, if you are running an aged care facility, there's a, hopefully there's a low risk that it would be transmitted into the workplace because of the controls that you put in place, but the consequences would be very serious if it was transmitted. And so once you've had a look at, okay, what are the risks? How likely is it that we may get a case of COVID in our workplace? Then you need to put in place, I'll just go back there, sorry guys, put in place what we call control measures to either ideally absolutely eliminate the option that COVID is going to get into your workplace, probably not a possibility at this point to completely eliminate, or then minimise the risk of it being transmitted. And, you know, there are some very simple things that I know you would all be very familiar with that you can follow. So the first one, I don't know about you, but my hands have aged, I think, 40 years in the last 5 months from all of the washing and the hand sanitizer that we're putting on, you know, wherever we go, we're putting hand sanitizer on. At the very base level, you do have an obligation as an employer. If you've got employees, you need to provide them hand sanitizer in the workplace, and also antibacterial hand wash, you know, in and around, you know, your bathrooms or wherever else they may be washing hands, kitchens and so forth. Now, the other big, obviously, ticket at the moment is masks. Do I have to be providing masks? Now, I'm going to take a stab that you're all in New South Wales. So the rule right now is you don't have to be, but it's recommended that you're wearing masks outside. I think that's correct, isn't it? When you're out in the community. So if it becomes an obligation that you must wear a mask at all times, then as a workplace, you would need to be providing those to your employees, even if they are, you know, have their own. You need to make them available to them. But right now, it's probably not the case unless you're in an industry or a business where it is, you know, important. So, for example, if you're a dental practice, you're going to be close up to people all the time. You'd probably need to be wearing a mask or providing them to employees who feel vulnerable and want to wear one. And then other PPE or personal protective equipment, like, you know, the whole full body sort of gown, eye shields, gloves, that sort of thing, that will all depend on your risk assessment and what your business is, and, you know, is that something that you need to be wearing? So, for example, I understand in Victoria during this stage 4 that they're doing, people who are working in meat processing facilities are wearing the full sort of, you know, alien suit while they're working. Those of you who have employees off-site, so someone like Dominic and I, we work off-site all the time. We, though I have been under house arrest for most of these last 5 months, when I'm out at a client, you know, on-site, the Employsure has an obligation to make sure that I'm safe there as well from COVID. So, for example, when the lovely people who book my meetings, they will send an email or have a conversation with the client to make sure that they've got appropriate controls in measure to protect me while I'm there. And that would be what you would be doing if you've got employees on different sites, whether they're, you know, construction sites or drivers or entering, you know, just going on client visits, whatever it might be. If you're not able to be comfortable and demonstrate that business that you're sending your employees to is able to provide that safe workplace, then you shouldn't, and, you know, hold your back at your employees and not have them there. You know, critical at this point. I won't go through this slide too much in depth, but just a bit of an overview. You know, as employers and business owners, you know, we have very high responsibilities for keeping our employees safe and anybody else who comes into our business. And you can see some of those frightening looking penalties if you know, there are breaches of work health and safety. And you know, for example, if we just look at that one, a corporation could be fined up to $3 million or if there's a death or a very serious injury on their workplace. So work health and safety is something that's really a critical part of your compliance for your business, and not just for COVID, but for all sort of work health safety areas.
Just to that point, Gwen, as we know, there's been some recent updates to work health and safety legislation, and New South Wales has been one of the first states to adopt a much more stringent policy towards whether businesses can either contract out of or insure their way out of WHS breaches. Now that's changed significantly. How's that impacted on employers and business obligations?
It has made it, I'm not sure that I could say impossible, but employers, can't insure away their obligations. If you can see on their individuals, so the PCBU, the primary, so the person where, basically the buck stops with them for a business and an employee, they actually face jail sentences now for we're calling industrial manslaughter is basically how it's termed. So if we looked at that horrible case last year, where that young boy, well, I want to say boy, young man, 18-year-old, the scaffolding collapsed and he died on a work site. The report hasn't come through from that yet, but I would assume, given there were multiple failures of safety there, that more than one person will face some sort of penalty. Whether or not anyone actually faces a jail sentence is, obviously remains to be seen. This is where I spend most of my day playing on a day-to-day basis. So for our clients, they have an option of having someone like myself. There's 5 or 6 of us, business partners around the country. We come and we can help manage meetings like disciplinary meetings and redundancies and bullying investigations and so forth to try and help mitigate some of these issues. So I want to just spend a little moment talking about what is unfair dismissal and how you as a business owner and an employer can mitigate those risks for yourself so far as you can. You may be aware an employee can lodge an unfair dismissal claim once they're dismissed. I think it's a $70 fee, so not very much. And it doesn't matter how frivolous their claim is or whether it's utterly based in no fact at all. There's no consequences for them for having lodged that. So as I said, we're seeing a 70% increase at the moment in claims, which is just causing great amounts of angst and stress to business owners in what is already a highly stressful time. So a dismissal will be deemed unfair unless there are 2 parts run. There is a valid reason for the dismissal. So, gone are the days where, the boss could walk in, point at someone, don't like your hairstyle, get out. It's, now there has to be a very valid reason under law for why that person is being dismissed. And then a fair process has to be followed. So, for example, and I say this to my clients, quite often, because they'll be like, surely we can just sack him. He's stolen $5,000 from us, for example. That's a valid reason, but you still then have to follow a fair process. And if you have one without the other, it will still be deemed as unfair. So a valid reason, there's both poor performance or misconduct, that it can be a valid reason. And there are certain employees who are, most of us are what we call a protected employee. So it's important to know if your employee has access to unfair dismissal. So depending on the size of your business, if your employee has worked for you for less than 6 months, they won't have access to unfair dismissal. So you've got a much easier time during that first 6 months to have a good look at this person. Look, they're not working out, move them on before they get unfair dismissal rights. Anyone who earns in excess of $150,000 is generally not able to claim unfair dismissal. Fair Work is basically like, you know what, you're earning good money, you're on your own, off you go. And certain employees certain businesses will have employees up to 12 months before they can claim unfair dismissal. It will depend on the size of your business. But ideally what you want to do is avoid a claim. So this is how one of the most important ways that you can avoid a claim, and that's to run a fair process. So these are the steps. Love the little graphics here. So number one, you have to notify the employee in writing that they are invited to a disciplinary meeting. I love that term, but that's what we use. We invite them to a disciplinary meeting. The letter that they receive is very clear about what that allegation or series of allegations are that they have to answer to. Then you give them 24 hours notice before the meeting so they can access a support person if they wish to bring a support person along. And that might be, someone as simple as, husband or wife or mum or dad, or they may choose to bring a union representative, or they may bring, even in some cases, they'll bring a legal support person, legal representative. You also then have to provide them an opportunity to respond. So in that meeting, you lay out the allegations and the employee has to have an opportunity to respond. Then you go away, you consider their response, and then you issue a written warning if what they, the allegation can be substantiated by the evidence. Then you have to give them an opportunity to improve that conduct or that performance before you run through that process again. Before you can look at, terminating, unless it's a very serious thing. We don't let someone steal $10,000 3 times before we terminate their employment, but it has to be a very serious matter before you can terminate them and move them on from your business. And there are certain things, another way that you need to mitigate your risks is be aware of other risks in the workplace. So this is a true case, this one. An employee reported to her, manager that one of the other employees was behaving a little bit inappropriately towards her, touching her leg, etc., asking her out. And she felt really uncomfortable about that, but she didn't want the boss to do anything. She said very clear, don't do anything about it. And so he didn't. He didn't take any action. And ultimately, that employer was found, guilty and had to pay damages to that employee of $25,000. So there is an overriding responsibility and obligation for you as an employer. If there is behaviours going on in the workplace, such as harassment, bullying and so forth, even if the victim, if we can use that term, says, I don't want you to do anything about it, you actually have a responsibility to do something. What that something will be is very subjective, and it will depend on the seriousness of the offending, but you have to do something on there. Redundancy. If I say redundancy one more time in the next few months, it will be too many times. I've conducted so many meetings, but it is so important right now that if you are running a business that might be needing to look at this as an option, you've exhausted all other options, in trying to save jobs, you've reduced hours, you've reduced salaries, whatever, and you need to look at redundancy. It has to still be what's called a genuine redundancy. And that is, generally speaking, that the job is going to cease to exist for whatever reason, whether it's because of technology or slowdown in business or a restructure, the job has to cease to exist in its current state. And so questions, can you make them redundant during these times? Absolutely you can, but there are risks involved. And what we want to talk about is very quickly talk about how to run a safe redundancy process so that it's not then putting you at risk of an unfair dismissal claim, because that is still possible even with redundancy. So this is a redundancy process. You can see there's 4 steps. Number 1, you have to warn the employee that their role is at risk. So you might have 10 people, but you have to reduce it by 4. So you will tell all 10 people, because they do the same job, your role is at risk. And you then invite them to a consultation meeting where you have to show it's a genuine exchange of information. You tell them why their role is at risk, why the business is doing this, and they say, hey, I don't think you should make my role redundant because I am basically you know, irreplaceable, and I do all of these things and I have all of these added skills, or I'm prepared to offer this, you know, what if I reduce down to 2 days a week, whatever it might be. And then you go away from that meeting, then advise them of the outcome. So, which could be, look, unfortunately your position is to be made redundant. Or it could be, we've got a deployment option, a redeployment option. We can offer you this job over here, or reduction of hours or whatever it might be. And then confirm that in writing to them. And if their position is redundant, confirm their redundancy payments, notice periods, all of that sort of stuff as well. And make it very clear. And if they're not to be made redundant, but they've gone through this process, again, you provide them with a letter to say that, that all's good, we're just going to keep going as we are. Very quickly, this is really important right now, creating and changing a contract. You may need to be reviewing your employment contracts right now to make sure that what your employees are contracted is still the most relevant and up-to-date information. You might be making some fairly substantial changes to an employee's roles right now. You might need to change that in their contract. You might be changing their wages and things like that. You may need to, if that's going to be a permanent arrangement rather than a temporary, change that in the contract. There have been a number of changes in legislation over the last 12 to 18 months. Personal leave is the one that comes to mind. You might need to update that in the contract. So, because again, if you get an unfair dismissal claim and the contract that they are handing Fair Work is substantially different to what they're doing right now, but it's in their favour, that's what they're going to be looking at for their unfair dismissal claim.
Gwen, just before we move on and start wrapping up, in relation to contracts, now I speak to, and as you know, we speak to business owners day in, day out. I probably speak to about 50 or 60 a week or more. I get regularly asked, why do I need a contract? And look, I've got a lot of, you know, casual staff and so on and so forth. Why do I need a contract for that? What would your response be to that, especially in the light of workpack reciter?
Yeah, there's no legal obligation to have a contract. But if you don't have a contract and it then becomes an issue, some issue is raised with Fair Work by that employee, the onus is on you to prove the arrangement that you've got with the employee. And if you can't do that in some way, and you can only do that using written documents, the claim and all of the information that the employee is sharing will likely be accepted as fact. And if we quickly look at the Rosato decision that came through in May, many of you might be familiar with that decision. It shot a big cannonball over the bow of many businesses who engage casuals. If you've got casual employees and you don't have a clear contract that says that A, they're casual, B, they're receiving a 25% loading to compensate them for their lack of annual leave and sick leaves and so forth, you're going to find it much more difficult to be able to defend a claim if that employee says, hey, I've been engaged for 5 years as a casual, but really I'm a permanent employee. I've worked 38 hours a week for 5 years. I want my annual leave and I want my sick leave. And if you haven't got something to back it up, unfortunately, given our situation or our laws right now, the onus is on you to be able to show that documentation. This is the last one I just want to flag for a little bit. Some of you are probably still engaging new employees right now. We know obviously lots of people are losing jobs, but Employsure I think has put on, I want to say 30 or 40 new employees in this period.
50 plus.
Plus, there you go. But many of them, they're not going into an office. They're doing this. They're going straight into a home office because we're, not able to operate our offices at full capacity. So, it's really critical that we take that extra step, even than what we would normally do, to make sure that they know what is expected of them and that they feel welcomed. Because if they're only welcoming themselves to their bedroom office, it's going to be a little bit less, more difficult for them to feel engaged with the business, to understand their role, and then to stay with you and for you to be able to retain them. Now, you may decide after 3 or 4 months, I don't want to retain this person, but hopefully your recruitment strategies have been such that you have employed an absolute gem, you want to keep them, but there's going to be lots of competition for that person in the marketplace. So we want to just make sure that we've got everything in place for them to be able to be comfortable, know their role, know their supervisor, know where they fit in the organisation, and be able to hit the ground running. So yeah, obviously introducing them to the team, you know, it'll probably for some of you it'll be virtual like we are here, but no, and for them to be able to know, look, if I've got a problem, who do I go to? Maybe not my manager necessarily, because this is only small stuff, but who is it that I will, you know, go and ask all those little questions about, you know, how do I put my timesheet in, or, you know, how do I access this particular information? Just really quickly, we're on all the socials, really good content on, particularly on Facebook and LinkedIn. Those of you who may be aware, our Managing Director goes live on Facebook at 12 o'clock every Friday, and has invaluable advice to share to all employers. Jump on. Rose has obviously watched it. She's nodding. Yeah, he's just quite extraordinary. And then he answers questions if you pose questions to him as well. Dom, I'll hand over to you. I'll click the slide there though, if you like.
Thanks very much, Gwen. Appreciate it. So, look, that was tremendous. Really appreciate it. Ladies and gentlemen, Gwen's got a lot of content. We are very resource rich. Obviously, this is a very truncated version of what we would do in a normal, you know, presentation or seminar. So just to wrap up from my side, we talked to, in terms of, in framing up Employsure, the 4 pillars of our service. And if you look at those 4 pillars, and again, we look at it as a structure of building your foundations of your business. Compliance is a process of review, audit, gap analysis, recommended action plan, implementation, where we will review all your current documents, policies, procedures, contracts, anything that governs the behaviours of the relationship with your employees, whether they're full-time, part-time, casual, or contractors, and that's another whole conversation in itself. We then augment that by delivering you beautifully written documents, policies, and procedures which govern the behaviours. We do that for both HR and for safety. The advice line, we have a team of several hundred advisors and consultants who are all Employsure people, all skilled and qualified and credentialed, who man the phones 24 hours a day, 7 days a week, and give you, as a members, tailored formal advice and update your documentation and assist with any of the issues that might present itself. Underpinning that, we have a large protection fund, which is not an insurance product. It's a nil excess financial risk product, which we make available for our members for a budget of up to $2 million per annum, which will then fund court costs, legal fees, expenses, you know, fair work compensation or remedy if we can't negotiate that away, or if we lose a case. And we've got a very, very high success rate of doing that. So representation is through Employsure Law, our partner law firm. This is all wrapped up in one subscription service to our members with additional smarts underpinning that. So I'm going to finish on the next slide, and I'm going to talk to just one thing. You can contact me directly on 0437 940 014, or my email address, which is dominic.fester@employsure.com.au. Any of the guest visitors and delegates that have attended today, or anybody that you care to introduce as a result of this webinar, is entitled to a free contract review. It's a service that we have. It's worth in excess of $500, and I'm making that available to any of the Parramatta Chamber of Commerce members, guests, board members, and visitors through this today. To access that, it's a simple matter of contact me, contact the Chamber to access me if you don't have my details now, or reach out to me via Rosa, Anthony Mazza, or anyone else here doing it. So thank you very much, Gwen. Thank you, PCC. Thank you, Rosa. I will now hand this back to Rosa to introduce our strategic